Good evening to all of you. We have with us a very distinguished set of lawyers and people who have shaped the discourse on corporate governance by their work. The theme of this evening's colloquium is Reimagining the Future of Corporate Governance, Law, Policy and Ethics. My name is Raj Kumar. I'm a professor and Vice Chancellor of OP Jindal Global University and Jindal Global Law School. Before I formally introduce my distinguished guest today, let me give a brief introduction to the theme of this evening's colloquium. Among many important things that history has taught us, one important takeaway has been that businesses are not just driven by the top and bottom lines, but also by the sense of integrity, transparency, and accountability to their stakeholders, not just the shareholders. The hidden force behind an organization is its corporate governance. Today, we live in a world driven by law and a myriad of regulatory and compliance mandates to ensure structured and transparent operations of an organization. Firms have the arduous task of not just maximizing profits and benefits for shareholders, but also ensuring accountability, compliance, ethics, and building trust. In fact, an organization's governance is not just about financial operations and transparency anymore, but also calls for an effective legal and institutional environment, an ecosystem that promotes business ethics and awareness of issues relating to environment and broader sustainability interests. To manage smooth amalgamation of all these expectations while collaborating among the management, the board of directors, the employees, and the shareholders is not an easy task, but can definitely be made easier if enabled by strong corporate governance. The business world has never been more dynamic than today, where a health pandemic is quickly spiraling into an economic catastrophe, taking businesses across the world into a state of paralysis. Not only are the economic conditions deteriorating at a dramatically high pace, but the certainty of the future makes it more difficult when it comes to even addressing the uncertainty itself. While regulatory bodies also relax some of their requirements under the current circumstances, it is evident that when they do see the light at the end of this tunnel, the way we sustain our corporate governance will define the future of organizations in a post-corona world. Corporate governance may not be the health of an organization, but it represents the state of hygiene. Hence, even as we go through difficult times, it is important that we stop and reflect on the values of corporate governance and address some of the most fundamental questions on the current state of corporate governance and the role of law and policy and ethics in defining them. Therefore, this colloquium is an important platform for us to reimagine the future of corporate governance. I have with me a very distinguished set of lawyers, and let me introduce them quickly. Ms. Alina Arora is the partner at Shardul Merchant Mangaldas. Alina has over 2 decades of experience specializing in the areas of anti-corruption and compliance, white-collar crimes and internal investigations, mergers and acquisitions, joint ventures, corporate governance, and many other areas. Alina is at the forefront of the corporate investigations field, acting as a trusted advisor to companies involved in large and complex cases. Alina has been ranked as a top lawyer in the white-collar crime practice by Chambers and Partners Asia Pacific 2019, among other recognitions. Thank you, Alina, for joining us today.
Thank you.
We have with us Dr. Akhil Prasad, who is the Director and Country Counsel, India and Company Secretary with Boeing India and is based in New Delhi. In the past, he has held offices as Head of Legal and Company Secretary with Fidelity Worldwide Investment, the Walt Disney Company India, and as Senior Attorney and Company Secretary of General Motors India. Akhil has about over 25 years of work experience as an in-house counsel and has worked with legal teams spread across different countries. Akhil is the Vice Chairman and Advisory Board Member to the Corporate Counsel Committee of the International Bar Association. Thank you, Akhil, for joining us today.
Thank you.
We have with us Mr. Suhail Nathani, who is the Managing Partner of Economic Laws Practice and is widely recognized as a leading lawyer in India. His work is across corporate, regulatory, labor, securities, trade, and competition law practices. He sits on the boards of listed companies as an independent director and has represented SEBI, CCI, and the Government of India before various tribunals and courts in India and internationally. He did law at the University of Cambridge, England, and has also received an LLM from Duke University. Apart from India, he's also admitted to the bar of the state of New York. Thank you, Suhail, for your time and being here.
Thank you, Raj.
We have with us Dr. Rajiv Oberoi, who is a Senior Group President, Governance and Control at the Yes Bank. He is responsible to direct and control the strategic actions and decisions of the bank and ensure that the policies and functioning are within the frontiers of ethics and regulations. Prior to Yes Bank, he was associated with the IDFC Group for close to 10 years as a general counsel, group compliance and audit head. In his illustrious career spanning almost 3 decades, he's worked with Standard Chartered Bank, Union Bank of India, State Bank of India, Reserve Bank of India, and Citibank. Dr. Oberoi is a lawyer and a Canadian Commonwealth scholar with a master's from McMaster University and a PhD in economics. Thank you, Rajiv, for joining us today. And last but not the least, we have with us Mr. Bharat Vasani, who is a corporate partner at Cyril Amachand Mangaldas' Mumbai office. Prior to joining Cyril Amachand Mangaldas, Mr. Vasani was legal advisor to the Tata Group chairman, having also in his earlier role been chief legal and group general counsel of Tata Sons Limited, the holding company of Tata Group. Mr. Vasani has over 35 years of experience at senior management level and has successfully built and managed the in-house legal departments of large multinationals. Mr. Vasani is highly regarded in government circles and in various industry organizations for his proactive approach on public policy issues. Mr. Vasani's contribution to the legal fraternity has been recognized by the Harvard Law School's Award for Professional Excellence in 2016. Thank you, Bharat, for joining us.
Thank you.
Before I actually ask the question, I want to say that, corporate governance and those who are responsible for ensuring corporate governance are by some people called as watchdog. To give a more graphic representation of that, we even have dogs barking as we continue this program. It's a reflection of the state of affairs that we're living in, so please excuse us for that. With that, let me begin my questions. My first question is to Mr. Vasani. Bharat, organizations are living in the midst of intense competition in a business environment, disrupted by shifts in technology, macroeconomics, and geopolitics, which challenge the corporate governance of organizations. And now, as if that was not enough, we are faced with COVID-19. Are the current corporate governance models sustainable and resilient enough to survive the current crisis? How should the policies of organizations evolve to meet the demands of the future business landscape? Bharat.
Yeah. Good evening to everyone. Well, let me tell you that not a single corporate board or risk management committee were prepared for handling this crisis. Nobody had a playbook to how to deal with this crisis. And the empirical evidence suggests that the boards have behaved very differently in this crisis. Now, I understand that the boards have to be more hands-on in this period, particularly if you are on the board of a company like hospitality or airlines or the front-ride retailing, where the impact of COVID-19 crisis has been the most profound, that you need to know. But what has happened is that some boards and some independent directors have become almost like a paranoid. And they have been almost becoming a burden on the management team by asking for holding a weekly or fortnightly board meetings and asking for all kinds of certifications to ensure that they don't incur any legal liability. Now, with regard to whether the current corporate governance structure is sustainable for current COVID and post-COVID situation, let me kind of make you some context of the entire thing. See, corporate governance has two facets: cognitive, and second is behavioral. Now, cognitive part, India has done the best. We have this clause 49 in the listing agreement, which started the corporate governance. It has been there since almost 20 years now. And we have the most detailed and elaborate rules and regulations on who should qualify as an independent director, who should qualify to join the audit committee and all the stuff. So cognitive part, both the Ministry of Corporate Affairs and SEBI are doing an excellent job. And particularly after the Kotak committee recommendations were implemented, we have one of the tightest regime on corporate governance. But in practice, we don't see that evidence. And why? The behavioral part remains unaddressed. So you may select an independent director who meets all the attributes of an independent director prescribed under law. But is this a sufficient condition? It's a necessary condition, but it's not a sufficient condition. What happens is how he behaves once he joins the boardroom is a major issue. And that is where India has faced the challenge. You just look at the 5 to 6 major corporate scandals which have come out over the last 2-3 years. What has happened? We had all the requirements were fulfilled. On paper, all the boxes were ticked. But in reality, the boards did not speak when they were supposed to speak. The board members did not speak. They couldn't control an uncontrollable, powerful CEO or a promoter. And those companies went through a profound economic crisis. Almost one particular case, the entire NBFC sector came down. Now, with this kind of situation, there are all kinds of debates. Is independent director really a workable proposition in Indian context where we are so heavily influenced by promoter and promoter culture, where promoter really runs the show and he selects the independent director, he decides his increment and remuneration, he decides whether he should continue on the board or not to continue on the board. In this scenario, is he really independent? And I don't think any amount of legislation will fix this. Cultural issues take a longer time to fix. We have made some progress. I'm not saying that I'm extremely negative, but if you see the evidence behind, if you see the statistics, and I get aghast if I look at the statistics, in 2018, some 600 independent directors resigned before their term. In 2019, 1,800 independent directors have resigned before their term. No, this is unbelievable. Then in 2018, 24 audit firms resigned before their expiry of their term because they were uncomfortable with certain accounting practices followed. In 2019-20, 35 audit firms have resigned from their job much before. This was never heard of in the past. And I'm not talking of resignations of the CFO and the compliance officers and company secretaries. So there are certainly a very serious issues in Indian landscape. And the legislator and the regulators are on a hyperdrive to make every conceivable change. As soon as they detect a corporate scandal, what was the mischief committed? They go by the lowest common denominator and change the SEBI rules and regulations. In fact, if you see the statistics of number of times the SEBI LODR has been amended, you will get aghast. But it will not solve the problem which is there. The problem which we are facing today is a cultural problem, that the people who are supposed to be candidly speaking up at the board meeting are not speaking up. The auditors who are supposed to remain firm while signing up the accounts are not able to sufficiently remain strong. Though I must say that auditors have now woken up to the serious liabilities issues, and with the arrival of NFRA, INDES, and this CARO 2020, they are now they are refusing to sign up the accounts where they are uncomfortable. But the entire cultural issue of a promoter sitting as a chairman of the board and everybody feeling terribly scared to speak because they feel. The other problem in India is that, most of the boards are packed with retired people. Somebody is retired as an executive in the board, some multinational company, somebody is retired as an auditor, somebody is retired as a lawyer. Now these people are looking out for an avenue to post-retirement job. They feel very uncomfortable that if I ask too many inconvenient questions at the board meeting, I may not be renewed after my term is getting over. So these are all the various factors which are driving the cultural issues, which are driving the behavior at the board meeting. And the statistics, when I was at Tata's, we had done a study at the Tata Management Training Center by an independent agency. We interviewed 100 top independent directors on the boards of various leading Indian companies on a no-name basis. And they confessed that they are not able to speak up at the board meeting, whatever they wish to express because of these fears.
Right.
So this is one of the issues which I think we'll have to fix it. And I've sat on international boards where there are very candid views are being expressed at the board meeting. Even if there are powerful chairmen and CEOs, still the board members don't feel intimidated by those presence and they do speak their mind. So to give you the answer, yes. But now in COVID-19 situations, what has happened is that my recommendation to the board would be, don't become a burden on the management team and the CEO. You need to really augment their capacity. Do where you are the best. I think they should have a very candid meeting with the management team that they tell me the areas where we can help you.
Okay.
So that is what I'm trying to say, that basically the boards need to work in a very collaborative way with the management team in current crisis, because they are already overstretched to deal with the crisis. And if the board itself becomes a burden, it's going to be a big challenge.
Thank you very much, Bharat, for setting the stage for the discussion today. Let me move to Rajiv. Rajiv, part of what Bharat is saying is that there are limitations for law to be effective in aspects of corporate governance. My question then to you is that law has always been finding it difficult. Now, has COVID-19 affected the industry and business organization in particular? How is the risk landscape different for businesses in developing economies? What kind of legal and business-related risk analysis should firms engage so that they can identify potential compliance and regulatory risk in relation to corporate governance or beyond in a post-corona world?
Thank you, everyone. And thank you, Dr. Kumar. See, I think like everyone has been mentioning that this corona COVID issue was never even contemplated in the living memory of many of us. Having said that, the impact which is making is still not very quantifiable, and how is going to impact the business is something which you and I have to keep on guessing. But when I see it from the corporate governance point of view and the boards which are grappling with the situation, wherein they have to ensure that their business runs, they are seen to be good corporate citizens, the employees have to be taken care of, the health standards to be maintained, and there is no stone unturned as far as the quality of health and the security is concerned. Now, in these situations, it's very important, and I have seen in my boards which I am closely working with, that the board is very focused on what is required to be done from the corporate governance standpoint. Now, corporate governance has a different test in today's situation. And I would like to put this because many people have not even thought about it. It is not that the company should do everything right. It is not that they should show their balance sheet, which is as per the statutory requirements. It's not that they should follow the LODR. It is not that the independent director should be independent. All that is taken for granted. What is more required is that in today's corporate situation, which is once in 100 years the companies are facing, does the board take the leadership to ensure that it works as a corporate board which takes care of all the stakeholders, as was being mentioned with one of our colleagues earlier? The objective of corporate governance is not to tick box all the things which are required from the law. The object of good corporate governance is to ensure the interest and protect the interest of all the stakeholders. Now, when I say stakeholders, yes, the business, the most important stakeholder is the customer who gives you the money. You cannot rule out the regulator and the law which you have to follow. You should not ignore your customer, which is your employee. And certainly you cannot avoid taking into account the extended people who help you, which could be your service providers and all. So in today's COVID situation, the most important thing is the corporate governance requires the softer issues, which I think, Bharat mentioned about the behavioral part. And that is very important in today's time. And many of the boards are finding this very challenging because they have their limitations also.
Thank you very much, Rajiv, for that.
Yeah.
Let me move to Alina. Alina, well, you've heard both of them, both Rajiv and Bharat, talk about the significant role and also the limitations as well of law at some level, and why it's important for the boards to be engaged in this. My question to you is that what role do you think law firms have in bringing an external eye to the very framework of corporate governance of organizations? I mean, you have yourself been leading several such investigations and work. What role do you think external organizations, but also institutions, including the role of auditors, but clearly the role of law firms in promoting corporate governance, but impressing upon the need for promoting corporate governance, both the leadership and management and the board of directors level within companies?
Thank you, Raj. I think the key point here, both what Bharat has said and earlier Rajiv has said, while the law firms can play a very significant role in guiding the board and advising the board on how to deal with situations and adhere to corporate governance guidelines, I think it's the culture and the behavior pattern again, that whether you're adhering to it merely as a procedure or in substance. So it's form over substance issue here. Most of the times we see that the boards and the management will adhere to all requirements on paper. And which is why when we do investigations, we find that if one was to just plainly look at the documents and the paperwork, it's all fine. There's nothing that can be detected. The auditors are never able to detect anything. Why? They are cross-checking everything. They are auditing the books and records. They are auditing procedures. They are checking on following of various laws, etc. But still, it's after decades suddenly that you see that there is a large fraud in the company, which is possibly so large that it has an effect on the entire economy at times. It's not limited. So the role of law firms and as lawyers for us is to be able to impress upon the board members, the directors, and the management that you have to substantively adhere to the law and also to communicate it down as culture within the company. I think the tone at the top, you lead by example, you make it very clear in running the operations of the company and the business that it's not just a tick the box. It's not mere compliance where you make sure everything signs up, all backup documents sign up, the auditors can't detect it. You genuinely have to follow it in spirit. And I think as law firms, while usually I come up when there is a whistleblower complaint or a red flag and you're investigating and trying to figure out what went wrong, in that process, we are able to explain and talk to the management and the directors to explain to them why it happened and why it's imperative upon them to understand the substantive aspect of the law and to change the culture themselves, because they are the ones who are going to direct the management. The management is going to direct, the workforce. And, typically it is said that, and this has been proven in the past, whenever there is a situation like this, where there is a pandemic, it creates a situation which leads to increase in frauds. It leads to a situation where the pressure of performing or surviving leads to, kind of letting go of corporate governance as such, because you're just trying to stay afloat, so to say. That's the excuse. Whereas if they are more transparent, Raju mentioned the word transparency, I think it's very important. If the management can be transparent with its employees, with its customers, and collaborate and create cohesiveness, collaboration, and transparency, I think a lot of issues of trying to, just kind of cook up your books, if I may say, or try and do tick the box compliances will change. And people would be more understanding to do business in a more compliant and ethical manner.
Thank you very much, Alina. Suhail, so literally, I think over 30 years ago, in 1987, there was a movie entitled Wall Street. Michael Douglas played the role of Gordon.
Greed is good. Greed is good.
Yes. So, famously, it was observed greed is good. And of course, we went through different types of crises, including the subprime mortgage crisis, and so much of legal and institutional mechanisms were put in place. But we are back again. So my question to you is that, to what extent you believe that the heart of corporate governance is about building a culture of respect for ethics and integrity, as opposed to having legal and institutional mechanisms which are constantly trying to create a culture of compliance, for example? What kind of balancing that one has to do? Now, I'm conscious of the fact that you're a lawyer and you head a law firm, but the heart of the problem seems to be is how do you build a culture of integrity and ethics?
Thank you, Raj. When you invited me to be part of this panel, I did do some thinking, and there are two hats I wear. One is, of course, managing my law firm. And the second hat I have is that of being a director on boards. And every day, every board meeting I sit on, this question that you pose keeps coming on. Let's get the law out of the way first. When I started my career, roughly about the time the Wall Street movie was released, I met a retired Supreme Court judge of India, and he told me, young man, show me the person and I will tell you what law to get him under. So there is a plethora of laws for everything. We can talk about form compliance, we can talk about substance compliance, but the fact of the matter is that is not the real world. Regulation will always, without exception, play catch up with conduct. And Bharat Bhai very nicely put it. He said, we have a tendency to take the lowest common denominator and then regulate after the fact and make it difficult for everybody. So when you talk about the law and how it impacts the boardroom, honestly, it's always going to be a catch up. Having said that, when you are sitting in a different capacity in a boardroom, not as an advisor, but as somebody who is charged under various statutes to do a certain duty towards all the stakeholders of a company, you start thinking and looking at things differently. I had the pleasure and privilege of spending 5 days at the RBI training college in Chennai when I sat as an independent director on the board of a listed company. And at the end of the 5th day, and I completed my term there happily, no long tail or whatever. But on the 5th day, I remember telling the RBI people, I said, look, it seems to me that I should give up my daytime job and just sit watching this company. The Banking Regulation Act has very, very high thresholds of what independent directors are to do and not to do. Now, when you talk about conduct, there are two types of conduct. Conduct that is deliberately fraudulent. That I believe you can address by picking the right set of promoters. So, for example, Mr. Vasani's former employers, you know those companies operate in a certain standard. I have the privilege of sitting on one of the NGO boards on that within that group. So you have a certain culture of a promoter. But then there are instances where I have been associated with companies where the promoter had no option because the way the regulation worked. So for example, telecom licenses getting cancelled overnight, coal mines getting cancelled overnight. What do you do? As Mike Tyson famously said, everybody has a backup plan until you get smacked in the face. And here we are in COVID, which is really a smack in the face. And we are dealing with a lot of these issues on boards. As Bharat Bhai said correctly, you don't become a burden on the management at this time, but you can't take your eye off the ball because there are a lot of things that are changing. What is happening is what the company is going on today. So, there is viability issues, there are issues about health and safety, but what sort of a company will emerge? Will that company be the same? Should the independent directors be asking these questions? So today I got off a board meeting where I asked these questions that, look, it's all very well, you're telling us what you're going to do to protect in last quarter and next quarter, but how are we going to emerge from these crises? I'm not the management. I am not going to be able to answer those questions. But we need to goad the management to start thinking of those issues because, quite honestly, they are caught within headlights right now. I'm happy to discuss this further.
Thank you so much, Suhail, for that, and I appreciate your candor as well. Let me go to Akhil. Akhil, so what is the role of legal counsels, general counsel of a company in maintaining the corporate governance of an organization? How do legal counsels adapt to the constantly changing regulatory requirements, especially when the changes are as rapid as those during the current crisis, but also how do you balance the competing interest of business development on the one side and regulatory compliance on the other? And what are the key challenges one experiences in managing issues like relating to conflict of interest and other types of issues in a company where corporate governance may just not be a priority?
So, Dr. Kumar, thank you very much. And, one thing which I would like to start with is not many people, I think, on this forum may agree with me. But one of the things which I've always insisted in all of the companies that I've worked for is that a GC should also be on the board. Because it is very easy for a GC to say and take a position that I have to, manage, I'm the advisor to the board. But the point is that if the directors, if we are telling the directors that the risk of non-compliance should go to the board and the GC is an advisor, I think it takes a very important aspect away, and the directors perhaps will not trust you in the same way that they should be, that a GC should be trusted. So one of the important things is, for me, I have always insisted and I have always been on the board, at least for my last two organizations. It was Fidelity. We were doing the mutual fund investments. We set up a $500 million fund. I sat on that board. Even in Boeing, both the entities, which are operational entities, both for commercial planes as well as for defense. I insisted, with my legal folks that I should be on the board, because if I'm there, I will be able to do a better role compared to just be an advisor. So that is one part. The second part is we have to have a compliance structure which has a mix of internal people working on it as well as external people who have to support the compliance. because we have to get the right reports. To give you an example, we are doing, say, construction of a campus, which is a 40-50 acre land we purchased. There are scores of suppliers who are working on that project. The labor law compliance, for example, is something. All labor law compliances have a prosecution of the directors. So unless you have something which comes to you as a general counsel and as a director, which tells you that these are the violations which have been done, the muster roll has not been prepared, the PF has not been deposited, the wages have not been paid, it should come to you directly as a GC, and then you escalate it to your management committee. The third important aspect, what I definitely feel now is a time which is very important, that we should take it very seriously, that we should have a business continuity program implemented in all companies. Wherever we are, we have to be very serious about what are those BCPs, whether a company has a BCP. In today's context, I heard people say that, there has been a lot of problem due to COVID. But the bright side of it is, if you see most of the IT companies, they have already practiced and implemented a BCP structure. They know how to do a flexibility. You have operations in India, you have operations outside India. You are able to rotate it better. Even during COVID, I would definitely say that companies who have very strong BCP programs will emerge faster compared to other companies which do not have a BCP program. So that BCP, and I sat on the BCP, BCP was reporting to me in Fidelity. We do have a BCP program also in Boeing. And I'm proud to say that ever since the COVID orders started on 25th of March, we did not have a single man-day loss in India. All our 4,000 engineers were able to work. The problem comes is on the vertical side of it. When I see that interdependencies, so if your ultimate customer is troubled, you may have a trouble also. But how quickly are you able to recover is one of the very important things. The fourth thing, which I would like to highlight for GCs is to take the risk register very, very seriously. The law has changed. It requires every company to keep a risk management process, implement a risk management process. The buck stops with the GC. The GC has to manage the risk compliance, the risk register, because through that risk register, you don't not only get the legal compliances, not non-compliances, but also the business compliances. So these are the four things I would like to, initially talk about, that this is, if you implement it well, if you are serious about it, you have a mix of external as well as internal people who work on a compliance program. I think that self-checking mechanism should be there in a compliance program, so you get the right message, and that voice you translate to the board, you are on the board and you take action. Unless all these come together, it will not be effective.
Thank you very much, Akhil Almo. You have given a kind of a recipe for being an effective GC, and I appreciate it, and very immensely valuable for those listeners also looking at the different the challenges that GCs face. For all those of you watching this program, we are live on Facebook and YouTube. I invite you to send in your questions. After we finish the first segment of this program, I will take up your questions with our distinguished panelists. Let me move to Bharat. Bharat, one aspect that gets, let's say, ignored at times is that how challenging it is to ensure effective policy implementation and data integrity while managing corporate governance in large organizations. Now, the traditional hierarchical corporate governance structure may have limitations when it comes to information processing. Therefore, to what extent should the corporate governance systems be decentralized to manage compliance more effectively? At the same time, there is accountability that gets vested with the key individuals and institutional structures within the organization. Having since you worked in a large organization and now, of course, at a law firm, I'm sure you will be able to have a better view. Please, Bharat.
First of all, I must make a distinction. I think it will be a mistake to confuse compliance with corporate governance. Compliance is a completely different aspect, which is the bare minimum with which you start. If you don't comply, you will go to jail. So compliance part, which is essentially a compliance officer's role, and many companies, this is being handled by GC also. is a basic function which every organization is by law bound to do it. I wouldn't like to confuse it with corporate governance. I feel the corporate governance principles are always better centralized. So for example, in the Tata Group, for which I worked the longest period, I can speak for, all the policies relating to corporate governance were finalized at Tata Sons level, which was the parent company. And all the operating companies, which included large listed companies like TCS, Tata Steel, Tata Motors, they implemented those policies. So governance policies are best centralized. They are not allowed to be left to the individual companies. In terms of the criteria we use for choosing independent directors, the kind of framework or the charter for the audit committee or the nominations and remuneration committee, risk management committee, always better centralized. But the compliance part needs to be decentralized because each businesses are so diverse. The requirement of compliance for a, say, hospitality company like Indian Hotels or a steel company like Tata Steel or a IT company like TCS are materially different. So the compliance part is so radically different. India has almost every company has more than 300 laws which are applicable to it, and there are unbelievable number of compliances. And now the rules and regulations are made by the delegated power of regulators, SEBI and RBI, and sector regulator. For insurance company, it is IRDA, and for banking companies, it is RBI, and for telecom companies, it is PRAI. Now, this maze of regulations are best handled at the individual company level, and the larger corporate governance principles are best handled at the parent level, because you can't have a difference in value system and approaches. You can have compliance details. So that is the best way to make a very clear distinction between compliance and governance.
Thank you very much, Bharat, for that. Let me move to Rajiv. Rajiv, we are, of course, familiar with the fact that successful corporate governance is driven by integrity of the data reported to not just the board of directors, but also what Bharat mentioned for effective legal compliance. Now, what is the role of, let's say, technological innovations in driving efficiency and transparency, but also data integrity in corporate governance? Now, of course, more recently, we have begun to rely a lot more on technology, but at the same time, we are equally concerned about issues of privacy, but also data integrity as we move into a more robust, technologically enabled world. In the context of the current crisis, how effective will technology be to mobilize board meetings and the continuity of corporate governance without affecting the integrity and ethics surrounding it?
Rajkumar, let me attempt to put the context of corporate governance into all the good things which a company has to do for an effective corporate governance.
Please.
Whether it is transparency, integrity, whether it is compliances, I think all are subsumed when you talked about corporate governance. And corporate governance gives you a larger picture of how a company has to be run within the parameters of regulations as well as ethics. So when you spoke about specifically about the data integrity is an integral part of the philosophy and the ethics and organization. There are ways and means, there are regulations that your data has to be vetted by, let's say, internal auditor, then by a statutory auditor, then maybe somebody for a financial sector, the regulator will come and verify. Those all are fine. But what is critical, especially in a today's situation, that you are able to give the right message to your stakeholders that your corporate governance is kosher. And how that can happen is to have a clarity and an understanding. Let me also, try to divert a little into the broader picture, a broader principle which we are talking. And I think Bharat rightly mentioned the cognitive part, we are more than good. Actually, if you look at it, the law is made and then the act has to be enforced. And there are enough methods to make the people do what they have to do. They could be penal, punitive, arrest also are there. The second part comes is that they have an army of regulators who want to enforce the law. And they come with the direction. You had the 2013 Companies Act, then LODR came in 2015. Then, you had so many committees, every committee improving. The next thing comes is that you have the boards. And that's what we are talking about. Do the boards have to have a effective corporate governance? And what that corporate governance would be? It's not that the circulars which you read, or you have the Kotak committee recommendation, or starting even from Cadbury committee, which is the father, and it has been evolving over a period of time. And as some of you have really been pointing out, that it is the culture. What you need to build is, and there are corporates in this country who have built the culture compared to others, where it is part of their DNA. Now, it takes a huge amount of time to build the positive kind of a DNA. And I don't have to talk about what should be the integral part of the DNA. It is very well documented, very well regulated, very well enacted, and everyone knows what they have to do. So that takes a huge amount of effort, and the term comes from the top. The tone is built by the top, the board. Now, somewhere I think Bharat, again, I always refer to Bharat, he rightly mentioned that if the tone has to come from the top, then it comes from the independents who are supposed to be a check and balance to the corporate objectives. It could be it could be promoters, it could be independent people, but they have to be controlled from the point of view of what they should and what they should not be doing, what they are supposed to report, what they are not supposed to report, how they are going to manage the board, how they are going to manage the management and direct them, and how they are going to manage the regulators. That is where the change comes, that the boards need to have a very strong and positive corporate governance culture, for which they have to build the DNA of the organization through the management. And many people come and tell me in the board that time when we are discussing, you're talking of culture. But when you come and ask me, Rajiv, Rajiv, should we do this or not? What is your answer immediately? If you tell me that LODR number so and so and Companies Act 2013 gives directions like this, RBI in the RBI Act 1949 says you can't do, RBI circular on corporate governance, no one knows what they say. I said, it's very easy. If you have the right culture, it's very loosely said, but it has a huge, strength in the word. It has to be a smell test. If you are aware of what is right or wrong, if you are aware that what you are supposed to do as a good corporate citizen and an individual, the smell test is good enough to give you a direction whether this can be done or not done. Any amount of authority, any amount of power, objectives are all put to rest, because when you are sitting on judgment in the interest of the organization, in the interest of the country where you are and the law of the land, you will certainly come with the right decision. Maybe not 100% right, but close to it. And that's where you require the wisdom of the larger wisdom of the board, where they can decide that if this is the DNA of the organization and this is the way we want to run, this is how we are ensuring that my cognitive part is taken care of, and this is how I have to decide this problem. Now, cognitive part is important, but it has become so important that you have lost track of the softer part of it. And you try to cover up the weakness through the maze of reports and, putting documents to everyone and saying, see, I'm totally compliant as far as this is concerned. But as far as the DNA is concerned, the culture is concerned, the value system is concerned, well, there is no measure for it.
Thank you very much, Rajiv, for that. I think one of the things which Rajiv and everybody seem to suggest, and I'm coming to you, Alina, is that we need to develop a culture of corporate governance, and a lot of which depends upon coming out from the board and the leadership as well. But at the same time, we know that some of these interventions that have happened over the last several years, if you look at the Sarbanes-Oxley Act itself, there were reasons for such legal intervention that have happened because, Enron happened, WorldCom happened. So, lawmakers had to respond to it. In our own country, we can have any number of examples. If you look at the SEBI's own thinking about corporate governance, there is a certain degree of, let's say, distrust that is deeply embedded in those notions of governance. And part of it is also in response to previous scandals. So my question to you really is that, both as a lawyer and as somebody who has seen it through this process, what should be the benchmark for assessing an effective corporate governance model? And what kind of, let's say, institutional mechanisms that go beyond law that we can actually focus on creating, where corporate governance becomes a part of an institutional culture and not limits itself to what even Bharat stressed upon, which is about mere compliance of rules and regulations, which of course should happen.
So I think definitely in terms of all the points that have been made, they're very valid and kosher. But in terms of, what I have seen in the course of investigations, and like I kept saying, the tick the box is always there. There is a reason why frauds, corruption, books and records, embezzlements is happening, and on a very large scale, despite, as we've said, very robust laws and regulations. And every time there has been a reaction from the regulators to come up with laws to address the issues that have been identified. I think the most important, at least for me, was making fraud an offense within the Companies Act. And it kind of pulls in various issues in terms of the books and records and how they are being manipulated, whether it is internally by embezzlement by employees, whether it is with the banks, whether it is with the other stakeholders that are doing business with the company. You've also created robust mechanisms to make sure that the auditors are checking all those, looking into whistleblower mechanisms. All of that has been done from the perspective of regulations. But to really institutionalize it, to make corporates want to adhere to corporate governance and standards in spirit, I think the environment overall of the corporate world and enforcement and the ease of doing business, everything has to change. You cannot just simply blame the corporates to say, okay, it's all your problem. Your intent was to defraud, or your intent was to do business in a particular way. Let's just look at why these issues are coming up. Every time a business is operating in this country, there are issues of obtaining licenses and permissions, there are hassles in infrastructure, the entire environment, tax, approvals, licenses, employment. There's so many regulations today. I think it's almost like you've been overburdened with compliance with regulations. And when you actually try to adhere to them, because of, and I'm going to raise an issue which everybody may not like, but I think the inherent DNA in this country of corruption at every level impacts the governance of business. Because when you're frustrated after investing so much to set up a business and you can't operate because of a silly license, I have seen companies ultimately figure out an intermediary to get past that hurdle because your assets are just lying there. Because the corporate environment, the regulatory environment is putting you in a corner. And you have to take care of operating that business and running the business. But these very legislations and laws are actually causing an impediment. And then the blame just shifts on the corporate saying, okay, you are not adhering to corporate governance standards. You are not adhering to the law. There is no remedy to a corporate if they are stuck with a particular license. They go on years and years and years and they're waiting for the license. But where is the remedy for them to continue their business and realize what they've set out to do and create shareholder value? Nothing. There is no remedy. The governance structure for doing business outside of the internal governance of the company needs to change so that the management and the companies can take the position that it is in our benefit if we adhere to this. So it's both ways. It's external and internal, and we simply cannot always keep saying change the culture internally, which would mean a huge financial hit to these corporates, because beyond a point, they're going to run dry of the resources of trying to withstand that pressure, and they're going to go insolvent. And the environment is not really going to care if that has happened. So how do you balance the two? I think we need to change the entire corporate environment and governance structure around corporate, rather than just burdening them with so many regulations and compliances which are tick the box. If ease of doing business is changed, if the general environment is changed, I think the institutional framework automatically will start feeling empowered to adhere to it. There has to be some benefit that comes to them.
Thank you very much, Alina. You raised the issue of ease of doing business. I'm about to ask that question to Suhail. Suhail, now tell me, what is the role of regulatory compliance frameworks in ensuring business ethics more generally? But more specifically, what are your views on the regulatory frameworks deployed by bodies such as SEBI or the Ministry of Corporate Affairs, and even current relaxations on account of pandemic? Now, we all know India recently improved its position to 63 in the World Bank's ease of doing business. To what extent have India's, let's say, attempted and at times even real change in regulatory reforms contributed to this? And how should they further evolve a stronger, let's say, economic enabled landscape so that not only we can fulfill corporate governance aspirations, but also to have businesses see value in promoting investment in India?
So Raj, I'd like to just pause here for a minute and just answer from my perspective, two questions you asked before. Won't take long, and then I will answer this question. One is use of technology in terms of information, which can strengthen corporate governance. I think it's a huge tool. Very honestly, communication through email, online board meetings, whatever you do electronically, like this interaction with you, will remain on the web forever.
Yes.
So the flow of information, the validity, the veracity, all that has changed with the use of technology. And I think a huge thumbs up. And during COVID, it's going to be all the more critical because even AGMs and EGMs are being recorded as per the regulations and the law. So I think use of technology definitely helping. The second question you asked is what can happen in the boardroom to improve corporate governance? There are two things from my perspective. One is communication, and two is access. When you are in the boardroom, you need to speak your mind freely and not look at the promoter or the chairman to answer your questions. Second, you should be free to talk to anybody you want at any level of the management to get the answers you want. Every board I sit on, I make it a point, and I stop sitting on audit committees out of choice. I still request the auditor to come into the room without the management or the promoter and ask questions. We must have that kind of access. And if you don't have that access, then that's a huge, huge alarm bell. Leave that now apart. To get to the questions that you asked on the regulatory regime. When I started my first question that you asked me, I said, show me the person and I'll show you the law to get him under. India has a plethora of legislations. Honestly, you sit in a boardroom, you could be violating a fire code. The fact of the matter is that what Bharat Bhai correctly said, that you over legislate looking at a crisis. You cannot assume everybody is a crook when you start legislating. And that is the problem of corporate governance today. Because you are so worried about ticking the box. If you see the statement made by our Honorable Finance Minister in the first speech she gave post the COVID crisis, she gave a series of speeches. The first one was how many compliances have been postponed. When we were done with that talk, I was laughing, saying that this is what the country has been reduced to. That, oh, this report, now we are changing it to this date. This, we are changing it to this date. This is not going to change the country, move forward. You have to be able to take risks. When I was a student in law school in the US, there was a celebrated case. The company had a limited sum of money. They had an path which was what the law would have said is the conservative approach. The promoter figured that that approach would have lesser chances for succeeding than if he went to Las Vegas and gambled the money away. What do? If he were to go and gamble the money away, his chances are better. But that sums up the dilemma in corporate governance. There are two choices at every point, and regulation empowers the regulator to look at it by hindsight. So Bharat Bhai will tell you that whether it is telecom, whether it is aviation, whether it is banking and finance, coal mining, there are two sets of regulators. Leave out labor, as Akhil spoke about, that is all encompassing. But when the sector you operate puts such onerous regulations on you, it's not going to help, because by hindsight, I can always get you. I can always say, why didn't you follow this path? Because that path would have not caused you the loss that this path caused you. So that, I think, is impeding entrepreneurship. and is making it more and more difficult for companies to operate in India. Let me put it this way. In your panel today, you have two general counsels. One works for an Indian company, one works for a global 50 company. And I have sat with global companies who have said, we want to exit India because we can't, quote unquote, manage the regulatory landscape. It's not about compliance. Bharat Bhai said compliance is easy. You need to have a small team. Compliance is fine, but the regulatory landscape is suffocating people from investing in India. Bharat Bhai, I see you wanted to say something.
Thank you, Suhail, for that very comprehensive response. That was much needed, and I think I appreciate again your candid response. Let me move to Akhil. Akhil, you heard what Suhail said. Now, of course, we also know business ethics is not just a matter of principle, but in eventuality, it also brings in more customers, top talent, more investment, and establishes a reputation for the organization. So my question to you is that, what are the different ways in which business ethics and corporate governance can actually be promoted and seen as something favorable for enabling a successful business environment? Over and above policies, what are the creative ways by which we can ingrain ethics on the business side of an organization?
I think, Dr. Kumar, it's more about doing walking the talking. We may organizations, you walk into some of the best corporate offices, you see posters on wall that speak up ethical values, ethical behaviors. All companies have those fancy posters, but the crux is how many of those posters are actually followed. And that is what I said in my opening view also, that if one has to be ethical, nothing stops you from being ethical. The question is whether there is a desire to be ethical, whether you want to do business in an ethical way. So that is the reason why I say that the positioning and constitution of the board has to be in a way that such things are constantly hammered right up to the board level. They may say that these things are very important: ethical value, ethical behavior. But when you come up with an ethical case, a situation, for example, doing a construction, somebody trying to bribe and obtain permits, some people, they say that, oh well, we had a constructive notice, itna to India mein chalta hai. India, if you have to do business in India, bribery and corruption is something you have to do it. We don't do it, our supplier does it. Our supplier does not do it, our dealer does it. We don't pay it directly, but we ensure that it is paid and things get done. We have to stop that culture. And unless we are prepared for a long walk, unless we are prepared to be very, very stringent, very, very focused, that whatever we will do correctly. There have been lot of times when such things come up to the GC office. People come to you, they talk to you candidly, and then then what do you do? Do you sit on it, or do you initiate and with your ethics team? And I'm suggesting that if companies don't have an ethics team, companies should have an ethics team, whether or not it reports to the board. Fortunately, most of the companies that I have worked for, they have a very strong ethics department. Some of the teams work under law, some of the things, some of the teams are in parallel to the law, but very strong in on ethics and business conduct. So that is, to me, the biggest concern. People are aware that, for example, there is an employee termination, a simple thing, which I will also say is not ethical. Somebody doesn't like somebody's face, your manager and your employee. The manager asks the person to be terminated. Is it ethical? Should not the GC office work with HR to do an investigation whether that termination was right or wrong? So this may seem to be a very small example, not a very relevant example, but if you collect examples like these, you come to know whether a culture of an organization is ethical or not ethical, whether people accept bribery, indirect bribery, to be an accepted norm, whether people are, for example, we see in some of the organization, the culture is to not treat women with respect. When people are talking to women employees, there is a silence in the room. The boss of the company is talking very lightly to a female colleague, does it not warrant that a formal complaint should be raised? So things like these, if you start assessing in your organization, you collect everything and then you develop systems and processes around it and then solve them. It has to be solved. And if a GC is unable to solve those problems, it is not the right place where a GC should be.
Thank you very much, Akhil. I have one question to all of you, and then we will get into our Q&A session. We are live on Facebook and YouTube, and I know you're sending in your questions. Do send it, and we'll get that shortly. And all of you, and I'll start with Bharat. So one of the things we are clearly, there is somewhat of a consensus in the group, really, that corporate governance is important, but corporate governance is also all-encompassing. So my question to each one of you is that, what are the measures that internally companies and organizations, even law firms, ought to take so that corporate governance does not become a major regulatory barrier imposed by government agencies, and it doesn't create new frameworks? Because we know that we have come a long way from the license Raj regime, in which for everything that we would do, we will need to seek permission, approval, and other such things. And that clearly promoted a different type of culture of corruption as well. So having come this far, if we were to recognize that there are inherent challenges towards building a culture of corporate governance, what should we be doing? What are the, let's say, best practices that we need to inculcate within organizations that will respect the role and importance of corporate governance?
Yeah, Raj, I will certainly answer this question. But before that, I wanted to deal with one issue which you asked Suhail about the ease of doing business. And I have a concern, in our obsession for this ranking that we have reached 63 now, and next steps we should be under 50. There's one danger which I have found. For example, there is now a talk about decriminalizing all the offenses. And they started with the Companies Act. First, they decriminalized some 14 offenses, and now a bill is introduced in Parliament just before Parliament started because of COVID. Is Companies Amendment Bill 2020, which has chosen 44 very serious offenses to be decriminalized. The objective is that ease of doing business, but it has become such a problematic criteria that they use one single criteria that everything which was compoundable offense, we decriminalize it. In the process, some of the very serious offenses relating to related party transactions, conflict of interest, misdeclarations in offer document, prospectuses, misdeclarations in director's report, all these serious offenses where significant public money is involved is also getting decriminalized. The bill is introduced in Parliament. There is no public debate happening in India. I'm extremely concerned that if this legislation gets passed, then India will become, people will say that, okay, fine, if there's a very malignant related party transactions, do it. It's a cost of doing business. We'll pay 10,000 rupees fine. The other thing which I'm worried about is that when the past when we decriminalized the offenses, like FERA became FEMA, all the criminal prosecutions were removed, but the penalties were significantly increased. So in FEMA, if you violate FEMA, the penalty is 3 times the amount of foreign exchange involved. But in Companies Act, we have a unique situation. We have not only decriminalized, the penalties for those offenses have been significantly reduced. And this may create a culture that no problem, violate the law so long as it's a penalty of 15,000 rupees and 25,000 rupees. We'll pay up the offenses, but we will indulge in those related party transactions. So this is one dangerous path we need to be careful about. Unfortunately, none of the peak media and the mainstream newspapers have caught on to this Companies Amendment Bill, which has some very malignant provisions, which if it is passed in the present form, then I think you need not worry about compliance with the Companies Act at all, because everything is getting decriminalized, all serious offenses. Now, coming to your question on see what has happened, Raj, I think we need to understand the culture and how the entire this LPG policy has played out, this liberalization, privatization, and globalization. We created a large number of regulators. And what has happened now, there's a race amongst the regulators. I have done a statistical compilation. Large number of regulations are framed without much of public consultation, whether it's RBI, SEBI, or any of the sectoral regulator. And as Akhil has pointed out, that in India, what has happened is now it has almost become a standard cliche that you can't do business in India unless you have somebody who can fix it. You need not dirty your own heads, but you have a supplier or a distributor or a consultant who will put it as a part of his invoice, but he will take care of the respective departments. Can I tell you something? In one of the companies where I was investigating, there was a register kept of bribes paid to various departments of National Highway Authority, a columnar register, because the boss was not trusting the junior that when I'm allowing him to take so much of cash, whether he's really passing it on to the respective government official or was he pocketing it. So he had kept a register, and when CBI raided the office, the entire register was caught. So this is the level to which we are operating currently. And this entire new set of earlier owned government businesses, telecom, insurance, aviation, when they are privatized, the amount of regulations which we have created and the frequency with which we are changing, I am telling you that it has become, even for a practicing lawyer like me with 4 decades of experience, I'm finding it difficult to keep track of all the changes in the regulation. And see Singapore, why there is so much of less corruption. When this COVID erupted, Singapore has passed one single legislation, COVID Act, which takes care of your force majeure issue, your material adverse change issue, your landlord-tenant dispute on rent, financing, moratorium. Everything is fixed by one single statute, which was discussed, passed, conceived, everything in 9 days. In India, we have 6,000 notifications issued by central and state governments from March 24th till today to implement various relaxations and conditions on COVID regulations. Each of the states, now I understand India is a more complex country than Singapore, but if you have to have such a complex web of regulations where 6,000 notifications have been issued just to implement the lockdown and to interpret that, and Singapore has managed it with one single law which will eliminate a large chunk of litigation over a period of next few years. And we have created a fertile ground where Supreme Court and High Court and various tribunals, when they start functioning in the normal way, they'll have a huge bunch of litigation flowing from there. Now, because of this extra dose of regulations which are being framed at a fanatic pace, I am telling you that unless we address this issue from the root, we will not be able to fix the problem of corruption.
Thank you, Bharat. Thank you so much for your, what can I say, a compelling response of the state of affairs. Rajiv, please, same question to you as well.
Right. I'll be brief, and I have to put a caveat that I'm a born optimist. And I feel that whatever we are saying and doing, things are going to improve, and they are improving. Restricting myself to only corporate governance, I think the corporate governance is improving. And when you are in a society which is market-driven or an economy which is market-driven, market will set you right. I do agree that there are so many regulations, and when you talk of the culture of an organization, you cannot undermine the culture of the country. And there is the culture in which we are working. So I would say that the environment, culture, regulations, laws, all that are like in a COVID situation, something we have to deal with. And anyone who has the strongest resistance will survive. Now, putting from my own point of view, I think corporate governance has been dealt by many countries, and India especially, by top-down approach. That I will make an act, I will put the regulators, they will issue the guidelines, I will get tested, I will make you responsible. Now, this has to come from the bottom. If you are able to train people, give them the right kind of training and understanding what the value system the corporate has, what kind of ethics we want to follow. And then you go to the next level where you tell them that if you have to do things right, this is how you have to do, which leads to a situation where the DNA of the organization is the way you want. It could be wrong also. There are certain organizations who have got a negative DNA and they only want to make profit. So be it. That's what it is. But that's not good corporate governance. And then you fit into your forms and substance part, that then your substance should fit into the form and reach the conclusion what the act wants or what the regulator wants. In my view, that particular thing has to come from the top, one. And second, the organization has to lead by example. When I say lead by example, it is not the board, it is not the CEO. Each one of us who is responsible for building a positive corporate culture, or the DNA, if I'm saying, should be doing it properly. And we have seen so many companies who have lived the way they wanted to live. I mean, I can tell you with a huge amount of confidence, I've worked for at least 2 or 3 corporates which had this DNA. We were working in the same environment. We were also dealing with the NHIs of the world and lending to everyone. I'm not saying that we were excellent, but as far as my DNA was concerned, I think we had developed a very positive DNA in a financial institution. And I can swear by it that we were, though in an environment where we are, but had a very positive DNA and a good corporate governance to best of our abilities.
Thank you very
You
much.
are absolutely right that it is the leader. I don't want to name the person who was a chairman, and he is a very well respected person of the financial sector or the country, and that came from him. I don't want to do this, and no one did it. I think I'll
Thank you,
rest
Rajiv.
my case.
I think there was, I mean, one of the things which is very, very important for us is that we are in different forms of transition. And as we move forward in that transition, it's important for us to reduce the gap between the normative legal framework on the one hand and the realities on the basis of which we are functioning. Alina, please.
I think from my perspective, what I feel is while we do react and make various regulations and laws to deal with situations that address the corporate governance aspect, what I have seen after having handled some very large, let's just say frauds, crimes, corporate crimes, the enforcement side is rather weak. There is just no consequence. And I'm not talking about petty, minor non-compliances. This is not about compliances and filings and reports. It's about substantive offenses, large frauds. It takes years and years and years for any effective enforcement to come about. And as a result of it, it's almost like, there is going to be no enforcement. So how does the law matter? And whereas if I compare it with other countries where the enforcement is effective, it is fast, swift, it is such that it actually impacts the business and sets an example so that the other companies are able to see it. It's made publicly available. And the other corporates are able to see that if we breach these corporate governance norms, there are going to be consequences that hit you hard, that hit the business hard. It's not about a 10,000 fine. It's not about, a minority here and there. And you say, oh, I've taken my commercial call. This doesn't matter. Let's just go ahead and do it. We are talking about large financial frauds that are happening in this country that are public in nature, that entail public funds and monies. And our enforcement is taking forever. Now, whether it is because our enforcement bodies do not have the capacity or they are not equipped or there are other factors at play, which we all understand, I think all of these have to be pulled together. So culture on one side, but I always feel that human nature is such that beyond a point, till you don't see an enforcement, somehow you just don't learn. It's almost like you have to be taught. And therefore, to that extent, unless and until we bring about enforcement, whether it is of the auditors, whether it is of the directors who are failing, or whether it is in terms of general large frauds, the corporates and the corporate criminal liability, it's something that is rather nascent in our country in terms of fixing liability of corporates and directors, and there is jurisprudence evolving still. We are far, far behind from the various developed countries. Unless we see enforcement against the corporates such that it actually hits them, they're not going to change, because we have been working in a particular manner for such a long time that it's almost impossible to change it overnight. And therefore, like I said, it's not just internal, it's external. Culture internally has to change. Enforcement has to come about from outside rather than just going on increasing the plethora of compliances, which I don't think address anything, because you not only have the general corporate compliances under Companies Act, you will have specific regulatory compliances, and the chief compliance officer can just kind of keep going through that. And yet, despite all these compliances to detect frauds, to report, to fix your books, they just seem to go on happening. There is just no dearth of financial institutions collapsing, banks collapsing, the very fabric of this country. Every other day we are reading about some large corporate fraud. And we have rulings and judgments that I'm not going to go into, but there is a judgment that says that we cannot rely on an Excel sheet that records bribes being paid to officials because it is not the books and records of the company. I wonder which company is going to record a bribe or cash generation and laundering in its books or minute it in the actual board minutes. So how the hell are we going to enforce frauds if we are not going to figure out what is the evidence we can rely on and bring about substantive change? So to my mind, I think it has to be a combination of all of these factors.
Thank you very much, Alina. Can we have Rajiv, please? Sorry, Suhail. You need to unmute yourself, Suhail. You need to unmute yourself, Suhail and Akhil, after Suhail. Yeah. Suhail, you need to unmute yourself.
Raj, so two aspects I want to address. One is an ideological one. Okay, more laws and criminal provisions in those laws will not work. I will discuss this with Bharat Bhai when we meet him on the Companies Act, or we can chat about it offline. But the bottom line here is, if you see a chart sheet post a corporate fraud in India, there will be at least 5 various laws that you are under. ED, PMLA, Companies Act, SEBI, and each one of these have different, and of course the Indian Penal Code, and each one of these have different places where they get adjudicated. Nobody gets convicted. Take two things. The Madoff scandal in the US, the largest Ponzi scheme in the world. Madoff was arrested. He got bail within a matter of days. He was in an electronic bracelet out on bail and eventually convicted for more than his lifetime. Now, why does that legal system work and our legal system not work? Because we have a plethora of laws, we have a plethora of regulatory bodies, enforcement agencies, and one after the other, they all attach assets, and it's such a mess. We have been involved in these cases, and of course, I can't discuss them for obvious reasons, but it's a nightmare. Everybody's attached the same asset. Is that going to help bring conviction? The only time people spend time in jail is the time before they get bail, when they are in for questioning. And please note that and see that. How many people go back to jail? We are not talking about the white elephant in the room, which is the enforcement system has failed. The second point I want to make is, look, we've talked about India DNA, but please, corporate fraud is not an Indian monopoly. It happens everywhere in the world. Wire a card, $2 billion, they did not verify a bank balance. Is that a matter of fraud? Who's responsible? Of course, we will come to know. But India does not have the monopoly on fraud. We, of course, seem to talk more about it because it comes into the newspaper. The governments have made corruption as a linchpin for whatever else. We'll talk about that separately. The third question, Raj, that you asked, which is the single most important question. More laws, culture, posters, everything will not help. It's very simple. Look at the internet. Several of us are old enough to remember Encyclopedia Britannica. Encyclopedia Britannica was the ultimate knowledge tool. For anything you wanted, they would publish once a year, very learned editors who sat there and wrote this all up, and they would update it year after year. And you know, there are many volumes that used to come of Encyclopedia Britannica. Encyclopedia Britannica has been taken over by far with Wikipedia. Wikipedia is the most bogus, useless source if you're unable to filter it. But what has Wikipedia done? Wikipedia has outsourced the collection of information. Now, if you're smart enough, you will figure out when you can use Wikipedia, when you can't use Wikipedia. I'm not advocating the veracity of Wikipedia. Similarly, every organization needs to have a robust whistleblowers policy. And the whistleblowers policy should be reporting directly into the boardroom and this is a dilemma I faced on many boardrooms. Will you accept anonymous whistleblowing complaints? Or will you have a witness or a whistleblower protection program which instills enough of confidence in the whistleblower to say that if I blow this whistle, I will be protected? There is a balance. There's no right or wrong. But I think a robust whistleblower policy with a transparent and speedy addressal system will help corporate governance far more than any more laws, any more criminalization, or any more so-called DNA and culture.
Thank you so much, Suhail. Suhail, I must say on the Bernie Madoff issue, while it was a $65 billion Ponzi scheme, which had some 5,000 plus people, investors who were affected, the fact remains that Bernie Madoff confessed the whole thing. In fact, the US Securities and Exchange Commission had done investigations on that matter before, and they couldn't find anything. So it was not one of those things where someone actually found it. So Bernie Madoff's case is a bit exceptional as well.
No, Raj, Bernie Madoff confessed to his sons who turned him in.
Yes, sure. But it's not one of those part of any investigation that led to finding it.
We can take any other case. Now, wire fraud is not a confession. We'll see how long the conviction takes.
All right, let's, please, Akhil.
Yeah, so Dr. Kumar, I started my career in 1991, and across, those many years, ever since I have worked, I have been extremely comfortable, on various compliance issues, advising the respective companies I have worked as GC, whether it was Electrolux or Xerox or Disney or others. There were some challenges, where you felt that, things are moving slowly, but over the course of the period, the transformation which various governments brought about, things are definitely looking better in terms from the legal side, how we are implementing those electronically, compliances, etc. What we also saw between 1991 and today has been a constant focus of India to really transform and integrate India into a global economy. So that has been one of the most important things that, we have been thinking about. And we have seen, with the various kind of reforms that has taken over the years. What is troubling me, and, this is my personal view, not essentially of my employer. My personal view is that we are now entering into very troubling times. Troubling times because of what is happening in the US due to its protectionism, what is happening in China due to its protectionism. These, economic superpowers are trying to protect themselves and insulate themselves, or being, their own country sentiment centric. I don't think our country can do that. It's my own personal view. I think our pace of reforms from the business standpoint should continue. And I would only, bet on our country's growth, which I am very, very positive about. That I don't, for a moment think that India's story is in the doldrums or it will not go forward. It is definitely, India has a very strong potential in the future, whether it's on the business side, whether it's on the compliance side. But what is troubling to me is, some of the things which have started to come very, very recently about protecting our own, having policies which are restricting or impacting competition, between the Indian players and the foreign players. The concept of coming again, to be self-reliant, it's a good motto, it's a good thing to do. But I think in that desire, we should perhaps not get into something which is irreversible, or which starts to turn away foreign investments from India. I think that is where I would be very, very cautious about. And that is what my real worry is going forward, whether we remain the wind in the sails are enough that we fly, forward, then, the progress gets derailed, is something which I would like to see continue to happen like we have seen since 1991.
Thank you very much, Akhil. Well, listen, this has been a fascinating discussion. I'm grateful to all of you. We have 75 plus questions here. Now, of course, we are not going to take all of them, so I need your indulgence. I'm going to pick up a few. So let's start with Bharat. Bharat, there's Abhilasha Ramakrishnan is asking, what should be the elements of a good business contingency policy, especially with regard to health, well-being, stability, and how it can connect with good corporate governance practices? You can have short answers, but we'll take up a few questions. Bharat.
Sorry, can you repeat the question? I'm sorry, I missed the first part.
Sorry. The question is from Abhinasha. She's asking, what should be the elements of a good business contingency policy, especially with regard to health, well-being, and stability, and how it is connected to corporate governance?
Well, I suppose this is very commonsensical that unless all your stakeholders are safe and healthy, there is no scope for a corporate governance to play. And I suppose what you mean by that, the elements are that there is a genuine commitment from the top for the health and safety of the employees of the company first, and of course all the stakeholders, and the safety of the products you make, the safety of the environment in which your plants are operating, the safety of the plants itself, and particularly in the context of recent accidents we are seeing in India. So unless you have a complete integrated model, then only you can have a better corporate governance. You can't have, in fact, and one of the theory which I'm propounding is that India needs to have a good public governance to improve corporate governance. They are so interlinked. This is not the topic for today's debate. But unless our public governance improves, we can't improve the corporate governance and all these aspects.
Thank you very much, Bharat. In fact, Rajiv, there are several questions exactly on that point. Ashutosh, Aditya, Sanjay, Pradeep, they're all asking, to what extent the emphasis on a corruption-free governance at the sort of more public sector will have an impact on the ability of corporations to become more responsible?
Well, I think corruption is something which we as good Indians take it for granted, which is wrong. I don't think the things are that bad in this country where people who want to run the business in the rightful manner, and I'm not saying for a minute also that they can do it the way they do in some other countries which have got lesser corruption. But the fact remains that the corporate governance is a kind of a torch bearer, telling the people who are working in the corporation and in the company that this is how we do our business. Now, I'm certainly not telling that if you do that, you are going to be, getting great business opportunity. But certainly, if you say this is how I run my business, so people who want to run the business the way you run will come to you. There are always good people in the world, and I strongly believe that if a company has a very strong corporate governance and policies which they follow with, and I don't want to take the name of the companies. I had a good fortune of attending one very senior Tata Group meeting, and one gentleman who was then the CFO and then the board member, he very clearly said, this is Tata culture. And each company can build that culture. And I have seen not many companies in India who have built that culture. And it may not be what you like or they don't like, but it is what the company swears by and what the company believes in, and what the company has the values and the ethics. And I think, in my view, public sector was something the gentleman who was asking question mentioned. Well, public sector is supposed to be kosher because it is run by the government. And as one of the, I think Akhil had mentioned, that we have to improve upon the cultural change, or the corporate change will come only if the country change comes. But that is something we are moving into that direction.
Thank you.
I mean, 10 years ago, what it was, today it's not there. And going forward, if we make our contribution as a good corporate citizen and with good corporate governance, our business model will also change and survive.
Thank you so much, Rajiv. Alina, there are a number of questions from Sanjay, Pradeep, Ananya, who are all asking about the role of lawyers, not just the role of in-house counsel, but also independent law firms when they are advising clients. To what extent law firms can nudge practices of corporate governance, even when they are acting as, in that capacity, because at the end of the day, clients are paying fees, and to what extent law firms become, let's say, more pliant with regard to, what they want to hear as opposed to what they need to hear.
Very good question. I think it boils down to, again, we'll be talking about ethics. And I think as lawyers, if we cannot stand up to ethics in our advice to companies, then I think it defeats the whole purpose of us being lawyers. So I don't think there's one thing to say whether there are options available within the parameters of law. And it's another thing to say whether we are pliant to say what they want to hear. I think there are gray areas of law which are gray. But again, if you go into the substance of the law, if you're talking about governance issue, then I think rather than advising on the technicality of finding ways, lawyers should, and law firms usually do stand up and give their position and are not easily malleable or cannot be manipulated. It's up to the management and the boards to accept the advice or not accept the advice. And I think in terms of a lot of issues that I think Sohail mentioned about having robust whistleblower mechanisms, since I deal with a lot of whistleblower complaints, issues where there are anonymous whistleblower complaints of, with respect to the operations and business and corruptions and frauds. There are a lot of times where we sense that the board is trying to use technical basis to say we should not evaluate this. Now, if you look at the substantive part and the purpose, then there should be a prelim evaluation to test the waters, whether there is any substance in the allegation, or is somebody just trying to, create issues for the business and put it off track. So by using prudence, you can actually do the right thing. And in this case, the lawyer has to advise the company on the right thing to be done. Because I've done several investigations where there have been whistleblower complaints once. The board has cursorily looked at it, put it under the carpet. It comes back again. They again look at it, put it at the carpet. And the third time, it becomes a very large issue. And when they finally decide to investigate it full form, you uncover a huge fraud. And why did it take 3, complaints? And for the board to say, okay, now we should really look into this. If they had just done some prelim work initially, that wouldn't have happened. So when the lawyer is advising and insisting, I think one also needs to remember that the lawyer can only advise. They cannot implement the advice that they're giving. Their job is to give the correct advice. It's the management's decision how they want to take the advice.
Thank you very much, Alina. Sohail, there are several questions which focus on the functioning of the board of directors as well. And you did talk about it. Pradeep Lokande is talking that can we, the heart of these set of questions that what are the incentives for board of directors to actually adhere to those ethical practices, particularly when a lot of which is dependent upon the incentives that the company creates for them to serve as board of directors? Can there be some new reforms introduced so that the board can play a better role?
So the structure as it exists makes the independent director wholly dependent on the largest shareholder. So the independence is always on or under a cloud, if you will. There are 2 things that you can do. One, which is already done, which is limit the term. Okay, that is a very important tool. And when you know that no matter what happens, the promoter cannot give you a longer term, I'm hoping that people's conduct will change. The second issue is we have not yet seen a fair amount of shareholder activism in this country. And the law has these provisions. I constantly look at them and test them and compare them with other global countries. And I often do wonder whether we, both from a regulatory perspective or from a tribunal perspective or a shareholder perspective, indeed, have the maturity to use these tools effectively. But in time, it will come. So see the number of corporate advisory services who now give reports on how large funds need to vote their shares. If they start playing a big role in the appointment of directors, the over-dependence, which is just natural in any situation like this, on the promoter group will greatly reduce, and you will see independent directors acting more independent. I don't want to paint them all with the same brush saying that they're not independent. Genuinely, people are independent. They do what they do very, very well. They are confrontational when they need to be, but we need to strike a balance between creating a confrontational board for everything, where the promoter is a crook, which certainly will not help anybody, including all the stakeholders. And two, where the independent directors get complacent and they turn around and say, look, this is a situation where, you know, I better be nice because he will not extend my term. So it's a balance.
Thank you so much, Suhail. Akhil, there are several questions on this issue. Sanjay, Chitraganda, and Ramya are asking, Sushmita as well. We didn't cover it because it was not so directly relevant in corporate governance. To what extent corporate social responsibility and issues relating to corporate responsibility is connected to developing a better practice of corporate governance, in the sense that should CSR be so independent of how the corporations function, or they should become so integral to the very functioning of the corporation?
No, I think that's a great question. And I would definitely believe that CSR is something which should be voluntary. You know, the way the regulations are turning it to be mandatory is something which I would not like to see. Because this is, again, something like what you talk about a corporate governance. So corporate governance, you know, you may have a lot of regulations around it, but the moment you try to penalize people for it, I think we go into a situation of independent directors not speaking up. You know, something like what was Arjun before the Gita sermon. So in the battle of Mahabharata, before Gita, Arjun was a confused person, but the moment Krishna came in, like a GC comes to the rescue of the board, the independent director starts to function. So that confidence has to come to an independent director from within, that, you know, somebody gives them the power to talk, to encourage them to talk, and that kind of power has to come. So that CSR also, you know, I believe is a very, very important integral part for a corporation, and it has to be within the framework of corporate governance, because even within CSR, what we have seen, some of the corporations have started to misuse the intent. So they have started to fund their own created NGOs, where, you know, you may show that the funds have gone to their own NGOs rather than achieving the intent of the social welfare. So that also perhaps is a role of a GC, in my view, that the GC has to be with the CSR committee and try and do a deep dive, you know, something like getting a end use certificate. I'm not mandating that to be a legal process, but something a GC should have a visibility on whether the funds which have been transferred to a CSR activity have essentially been utilized for that very specific purpose, rather than, you know, meeting only the objective of Section 135, which should not be the intent of the board. So that is where I would see it.
Well, thank you very much for all of you. It's been a fascinating discussion. I still have some 60 questions unanswered, but we will leave it for another day. I have one last question to all of you, and that can be a short response. For those students of law who are watching this program, what would you like to tell them about their own future careers in law, especially as they experience the uncertainty of this crisis, along with their studies in law schools across the 1,650 law schools in India? What is your advice, Bharat Vasani?
Yeah, can I tell you, this time shall also pass. And second thing, the future of lawyers. Let me tell you, basis the experience of my firm, we are more busy this year than the last year. So the crisis has created a phenomenal opportunity for lawyers in terms of advising on force majeure, material adverse change, supply chain disruptions, financing issues, corporate restructuring in the absence of IBC. So I think the future of the legal profession in India, and particularly the large corporate law firms, I see a great future ahead. In fact, this crisis has created a new opportunity of several new areas of practice which has emerged. And I would recommend to all the young budding lawyers from the law school, they should not even have an iota of doubt in their mind that this COVID-19 has anyway negatively impacted their career prospects. In fact, if there is an impact, it's a very, very positive.
Thank you very much, Bharat. Rajiv. Unmute yourself, Rajiv. Rajiv, unmute yourself, please.
Yeah, I think what I would like to tell the young budding lawyers is that this is the right time and the right place to be in this particular profession. And it has evolved over the time. Today, if you ask me, with the economy changing into a service economy, and within the service economy, the more important has become the advisory part. So it is the legal profession, the consulting profession, which is going to have the future in this country. And with the globalization and the laws and the trades going across, you can't live without a lawyer on your side, which is true. And I think they are in the right place. As regarding this particular topic, which we discussed for the last 1.5 years, I would like to give my 2-penny bit is that have your right value systems and ethics. Being a good lawyer, wherever you are, whether you are in corporate or like Akhil as a general counsel, or even in the law firm, value system is something which goes with you till your grave, and that makes you a different person compared to others as far as a human and an individual is concerned. And if you are a good human, knowledgeable person, success will always come to you.
Thank you very much.
Especially if you're in a legal profession going forward.
Thank you very much, Rajiv. Alina.
I think my advice to all the young students, I think law is a great profession. Not only is it intellectually challenging, evolving, it's like solving puzzles. I think it kind of empowers you to bring about a change. It's a voice that will be heard depending on whether you want to truly exercise and get into it. The key here is understanding law, not in isolation as just sections and provisions, but understanding the role of law in society, in the corporate world, in the international world, and in the governance of the country as such, and the interplay, and then playing a significant role. So while you can achieve personal, professional satisfaction, it is very financially rewarding. For me, what really makes a difference here is that it's always a new challenge. It's always something new, and you can bring about a change or a difference. You can grow every day. You can learn every day. You're never, ever stagnant. And I think that's something, at least for me, keeps me going, where I know that I will, even at the age of 80, if I live that long, I would still be contributing and learning something new every day.
Thank you very much, Alina. Suhail.
Mute.
Suhail, you should unmute yourself.
I did, but my computer is programmed, I think, to switch on the mute periodically. But anyways, let's get to the question at hand. Yes, parts of the practice are exceedingly busy, and we've never seen that kind of work in terms of pressure and deliverables. But make no mistake, what your clients are going through, law firms will go through. Okay. What do you need to be successful in this environment? And that applies through your career. I tell every young lawyer in my law firm that if you expect to start in one area of the law and finish in that area, you have another thing coming to you. You need to have adaptability. You have to adapt with what is available, what the environment is, and how you can be part of that change. Shipping law was, when I was practicing, a very hot area to practice. It still remains an area, but certainly no longer the growth area in India that it was. So you have to keep on adapting. Two, as Dr. Oberoi said, and this is very, very critical, your ethics. There are two things that drive your ethics. One is, how do you want to go to sleep at night? Do you want to be honest about what you have done or not done during the day? Early in your career, you have to set the tone. And let me put one practical advice. Over dependency on one client or one partner will eventually lead to you being in a position where your ethics will be compromised at some point. So you need to have a diverse pool of work in your area of practice. You may choose to do corporate law, you may choose to do SEBI. And one final thing, you have two very accomplished general counsels on this call. Every client of ours has an excellent legal team. They come out to the law firm when you can bring them incremental value. Budgets are tight. They're not spending money on lawyers because they have fun. They're spending money on lawyers because you bring them value. So in your career, position yourself so that you can bring value to your clients. You need not be the cheapest lawyer. value is a different proposition from being cheap. Thank you.
Thank you very much, Suhail and Akhil, please.
So, Dr. Kumar, one of the important things that I have seen, especially with institutions like yours, have brought forward the value of being a lawyer as well as on the commercial side. So we have seen BCom LLB, BBA LLB. Internationally, Dr. Kumar, you know that many lawyers have been very successful CEOs. And that is one area which I see for future very distinctly, that we are not only confined to be lawyers. We bring a very strong commercial and a legal sense to the boardroom. So I would definitely like to see in future many of our Indian students becoming not only good GCs, but also CEOs or COOs or CAOs, which is but logical, a thing which is associated with us, because especially with Bharat and with Rajiv, on this call, and especially on the practicing side, we have done so much, deals, transaction, business development. It is but natural for lawyers to ultimately take up those roles also. Why should I only be confined to a legal advice? I can become a CEO. That is where I would like to see our students, taking it very, very aggressively, develop their commercial mind, like they are developing their legal mind, so that they become very sound CEOs. And why? Because if you are a lawyer also, you are able to do a risk assessment better than most of the others. So that is where, you can run business more professionally, valuing the risk and things like those. So that is where I see students, I would leave that message for students that aspire to be CEOs.
Thank you very much. Thank you very much to all of you. I would like to thank Alina, Akhil, Suhail, Rajiv, and Bharat for really, being part of this absolutely phenomenal discussion. I learned a lot. I'm sure the viewers and our students, and of course, lawyers and others who are part of this colloquium learned a lot. I deeply appreciate your personal contribution, your commitment, your dedication, and indeed your leadership in promoting corporate governance in your own careers, either as a general counsel or as a lawyer in a law firm, or people who have been thinking through these issues. I'm grateful to you for sparing your time and being part of this colloquium. I also want to thank all the viewers. Sorry that we couldn't take all the questions, but I deeply appreciate that you joined in this colloquium. I also want to thank our media partner, Live Law, for promoting this event. This is part of a public interest initiative that OP Jindal Global University and Jindal Global Law School is promoting. I host 2 colloquiums every week. We will be meeting again on Wednesday, the 8th, on a Law University Vice Chancellor's Colloquium on the theme, Reimagining the Law Schools of the Future, Role of Public Law, Technology, and Social Responsibility. I will be joined by 5 Vice Chancellors of National Law Schools of India, starting with Professor Dr. Nishita Jaswal, Vice Chancellor, Himachal Pradesh National Law University, Professor Dr. Vijendra Kumar, Vice Chancellor, Maharashtra National Law University in Nagpur, Professor Sri Krishna Deva Rao, Vice Chancellor of the National Law University in Odisha, Professor Shanta Kumar, who heads the Gujarat National Law University, Gandhinagar, and Professor Vivekanandan, Vice Chancellor of the Hidayatullah National Law University. Thank you very much. Stay safe and look forward to seeing you.
Thank you.
Thank you to all the panelists.
Thank you.
Thank you.
Bye.
Thank you.